Okay, let me just start here. All right, disclaimer, nothing in this video can be used against anybody, including me, myself, the company. All right, so the information here in this presentation slides are prepared by myself based on my best knowledge. And sometimes, yes, humans do make mistakes. So please forgive me if I made any mistakes, okay? Okay, let's come back to the very fundamental, yeah? So what's a patent? A patent is basically an exchange of, informations and the monopoly of grants. Basically, as an inventor or patentee, you are required to disclose your inventions to the authority, to the government, okay, to MAIPO in Malaysia. And in exchange of, the government will recognize your invention and thus grant you a monopoly for 20 years. That's the deal, you see, that's an exchange. You disclose whatever you have, in exchange, they will give you a recognition, if, of course, subject to the, you have fulfilled all the law and requirements as per stipulated under the Patent Act. So in order to become a good patent drafter next time for yourself, you need to get one copy of the act here for Malaysia, the Patent Act 1983 and its regulations. This is for your reference. Okay, let's look at the Patent Act. Yeah, let's see what the act actually requires. Now, we know that when we disclose our things, inventions to the government, so what are we actually disclosing? So today, we are going to talk more about it. Okay? Wait, let me just test the microphone. Should be all right. Okay. Okay. All right, let's continue. Okay. Now, in an application for grant of patents, in every application, it shall consist of a request. A request, basically, you fill in the forms, okay? The specific form required by the patent law. And you must provide a patent specification which consists of descriptions, B, claim or claims, drawings, and abstract. So these are all the ingredients that you need to disclose to the governments, okay? In exchange for, maybe they will grant you a monopoly rights, okay? For all the Q&A, please do it after. We're not going to have any Q&A for these sessions, yeah? Because I need to finish and complete my webinar first. Thank you. Okay, this is one of the example of the US patent. You see, it consists of the, the descriptions, the drawings, etc., etc. All right. So let's look at the Patent Act, the Patent Act 1983. Let's look at what it requires us to do. Under regulations, wait, this is what, sorry. Okay, under regulation 12 for descriptions, okay, every description, every patent description, it shall begins with a title, all right, and then followed by a technical field. So you have to explain in your novel, in your so-called technical novel or write-ups or specifications about the background arts, the field of technology that you are involving. So you are trying to tell the examiner this invention is relates to blah, 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 automobiles and all this thing. Next, you need to disclose the invention in such very details so that any person having the ordinary skill in the art can actually know how to carry out your inventions. All right, you need to disclose everything about your inventions. You cannot hide it. When you hide it, it's going to be a big issues later on, which I explained. I'll explain later on. And of course, description, that's description part. Okay. Next, Regulation 13, you must have a claims, a section to claims. There's a claim part here. Now, when we talk about claim, it doesn't mean that you claim, you know, it's not a demand. You know, a claim is basically a technical projections of your inventions. So you see, under the Regulation 13, the rules required you that claims must be clear, claim must be concise, and it must be fully supported by your descriptions. So if you do any claims here, you must explain what is this all about, or what are the elements all about, the relations with the elements and all this thing. Now, all the claim must be numbered consecutively. And in the claim part, you shall not put in drawings. It's only wordings. So it's only wording that portray the actually the what do you call it, the scope of your inventions here. Okay. And then of course, claims, you must have a reference sign, and the sign you must relate to the drawings, and of course used by when you describe your elements in the descriptions. So what are the claims actually? Claim is a statement. It's basically a statement, okay, to describe the technical features of your inventions. So in the claim, is the most important part is that you need to tell the examiner to where the extent of your novelty or the inventiveness of the inventions. Okay, we call it the characterization portions. I will explain that in a short while. So claims, you have the independent claims, and now you have multiple dependent claims. Dependent claims should be read together with the independent claims. Now you must have drawings if required. Okay, if it's better to put in drawings. The drawings will give the examiner or any person, any public persons, to have a better understanding of your inventions. The last thing you need to do is you must have just an abstract. Abstract is something like a summary. Okay, according to this abstract, Regulation 16.4, it's a summary. I would say like it's a summary that indicate all the technical fields and all this thing, and then no more than 150 words. Please remember, no more than 150 words. You don't need to write a one page A4 pages for A4 page for the summary and for the abstract part. Okay, and remember, abstract, according to the Regulation 16, do not contains any statements or merits. Don't mention that my invention is the greatest thing of all, like that. No, don't do that. Okay, purely technical, just purely technical. And then you may illustrate by any drawings if you want to. Okay, just one perspective drawings. Okay, that's the law part. And most important of all is that I know a lot of people, you want to save costs, and you want to put in like 2 or 3 inventions into one application, one patent applications. Can you do that? So under Section 26, unity of inventions. Now, you see, the law says that an application shall relate to one invention only, or to a group of inventions linked to a single general inventive concept. So if you are patenting on something A and you talk about something B, which are totally not related at all, so cannot. You must put in 2 applications, 2 separate applications instead of 1. So you don't draft everything in at one go. Okay. So unity under Regulation 19, under this unity of inventions, of course, you can have more than 1 independent claims for each of your patent applications. You can have independent claims for the apparatus, okay, for the machine. You can have another independent claim for a process. So you can have another independent claim for something else. So, but as long as it contains or it relates to the same general inventions or inventive concepts, then you can do it. You can have more than a plurality of independent claims. Okay. Now let's come to the most exciting part: drafting your patent claims. So I know everyone here is very eager to draft their own patents, because you don't have to wait for me to draft for you. I hope that everyone can be a patent agent. I hope that every uni can do your own draftings, because I have been in the drafting industry, patent industry for 19 years. We drafted more than 1,000 patents actually. But I would like to share this very fundamental skill with everybody. I hope that, we always want people to progress. That's how we progress, how Malaysia can progress. So, okay, drafting your patent claims, yeah. Now, before, from the perspective of a patent drafters, okay, whenever any inventor wanted to file patent applications, so these are the questions that the inventor must ask himself. Number one, what has been invented? You must tell me what are the things that you must tell yourself. What has been invented? What are the claims to the inventions? When I mention the claims, it doesn't mean anything to do with money. It doesn't mean anything to do with the legal. I mean, the claims is the technical boundary, the technical boundary of your inventions. So does the inventor know what he wants to protect? So you must be very certain and sure that what are the things that you need to protect, and how should we claim the inventions? Okay. So what are patent claims, ladies and gentlemen? The claims mark the boundaries of protection provided by a patent. The claim defines the scope of patent, scope of protection by a patent. Okay, claims are very important. Today lessons we are talking just on claims itself. How to draft a claims. When you started drafting a patent, the first thing you do, you need to figure out how your claim should be drafted, so that it will be interlinked with your descriptions and abstract later on. Most importantly will be the claims, because when in any patent litigations, the court will normally look at the claims, will interpret your claims based on your claim technical writings, literary or purposively or equivalence, or that's the method that they're going to use. Okay, so the claims clearly, concisely tell the world that what the patent applicants claims his or her invention to be. So claim format. So how do we draft a claim format? It's very simple. There are three parts to a claim. Okay, the first thing is called the preamble, and transitional phase, and the body. So if you look at the what they call it, the claims on my left side, which is I think on your right side, you will see that I'm trying to say is that a box comprising a lid with a hinge. Okay, so you see a preamble is an introduction part. Basically, it tells what are you talking about. So you can start off with something like an apparatus for cooking rice or cooking, or maybe you can put a method for something else. Then the transitional phase, okay, that will be the preamble. The preamble. So you must know, you can use the word such as apparatus, usually for structural, for machines, articles, compositions for chemical, method if you're using it for the technology, I mean for software, for algorithms, for even for chemical formulae, process. Okay, these are the words that we normally use for the preamble. So if you want to talk about process, I will just put there a process of making this and that, or maybe an apparatus of this and that. These are all preamble. Okay. Now, example of preamble, let me give you an example. Yeah, we are looking at a rice cooker example. So the first one you see in the if you look at the red line, an apparatus for cooking rice. Quite specific, right? You see for patent draftings, we tend not to be too over specific or narrow because we want to give the wider protection as possible. So assume that this apparatus or this device can cook all kind of grains. So I need a broader preamble. So can I write something like an apparatus for cooking grains? Oh yeah, you can do that. But it seems like this apparatus can cook anything, okay? Vegetable or melting cheese or all these things. So I need a broader preamble. And therefore, I decided to put an apparatus for cooking. So that means I'm not limiting myself only to the rice. I'm not cooking grain. I can do grains, I can do vegetable, I can do anything. If I just put an apparatus for cooking rice, then it's very limited, it's very narrow to only rice. Okay, so preamble is very important. You see a few words like all this can make a difference for your patent applications, for your patent infringement claim next time. Okay, so that's preamble, yeah. Next, and preamble always followed by a transitional phase. Now there are two kinds of transitional phase. We have the open-ended and the closed-ended. Okay, so it's very important that you must apply which one to use for your when you draft your patent claims. Okay, a good drafter will always advise you to use an open-ended, but in certain cases you are required to use a very narrow one, which are the closed-ended. Now let me give you an example of the open-ended. Open-ended phrases are inclusive, not exclusive. They're very inclusive. Now you can use the words like example, comprising, including, containing, or characterized by. Now these are the words that patent drafters or patent agent normally use when we want to explain. We are telling the examiner that our apparatus or our methods or process includes or comprising of of all this. So you must play with the words, either open-ended or closed-ended. Now let me give you an example of a transitional phase and open-ended one. Look at this. An apparatus comprising a pencil, an eraser attached to one end of the pencil, and a light attached to the center of the pencil. So you see, if you observe that in this claim, we are using an open-ended phase, comprising. So we have expanded it to include, to allow other elements to include. It's not just very narrow, it is inclusive. For example, this claim leaves an open possibility of including a cap for pencil. Okay, put another way, if an accuser infringer could avoid finding an infringement by asserting that his product also had a pencil cap. So the word comprising in everyday language for patent, it means includes, contain, comprehend, consists of all these things. Okay, now you must be very careful when you choose to use the word comprising or otherwise. Okay, let me give you an example of a closed phase, a transitional phase. Now, closed phase are opposite of open-ended phase. Closed phase, normally we will use the word consisting of instead of comprising of. You see the difference? Comprising, consisting. Okay, so when we use the word consisting, it's only limited to the claim to nothing more than this specific recited elements. Meaning that if I mention this, it's only this, nothing more. Okay, nothing else, nothing more. So the previous open-ended example can be rewritten in a closed form as follows. I'll use back the example of the previous example. So now I want to make it a very narrow claims. So I'm going to use the word consisting of, an apparatus consisting of a pencil, an eraser attached to the pencil, and a light attached to the pencil. So if I use this word consisting of, and this claim will become a very narrow closed claim and only includes 3 recited elements of the pencil, which are an eraser, a light, and nothing more. Okay. So when you draft your patents, it's very important that you must think carefully whether you would like to use a closed-ended or an open-ended. Now, there's no wrong to using a closed one. But of course, as most experienced drafters will rarely write a closed claim, okay? Because it will basically allows infringer to easily avoid the infringement by simply adding another elements. So in short, it's always advisable to amend claims to avoid prior arts, but in a manner that still make it difficult for competitor to avoid the claims easily. So this is your choice. You need to know how to use an open transitional phase or a closed one. In some country, when you file your patent overseas, especially like in Australia, the word comprising sometimes interpret as a narrow closed transitional phase. And of course, in many countries like US, UK, the word comprising is actually open-ended. Even Malaysia, we interpret it as an open-ended transitional phase. Now in Australia, if they use the word including instead of comprising. So it's very important that you must know when you file your patent overseas, we normally usually consult the local patent drafters in that country to check the claims and make sure that we never use the phrase wrongly, or we are actually limiting our own scope. So next, the third part will be the body of the claims. So you have the preamble. Where is it? Okay, you have the preamble, you have the transitional phase, and now the third part will be the body of the claim. So the body of a claim is the portion that it follows after the transitional phase. So basically, the body of the claim recites all the elements and limitations of the claims. Now, you cannot just mention or recite the elements like a checklist 1, 2, 3, 4, 5, 6. You need to explain the relationship, the technical relationship between one and the others. Okay, you must mention that components A or element A coupled to element B, or maybe element B is coupled to element A for what purpose or whatever. Okay, you need to build up the relationship so that it doesn't like left single and lonely, and you must explain it. You see, the whole idea is that the body of the claim actually, using words to portray the technical limitations of your inventions. Okay, let me give you an example of the claims. Yeah. You see here, an apparatus for holding items comprising at least one leg and a top configured to support at least one leg. Okay. Now in this claim, the body recites 2 elements here. At least one leg and a top that supported by at least by the one leg. Okay, let's think about it. What product is this? The body of the claim also connects the leg to the tops. It's very clear that, you see, in this claim that a top configured to support at least one leg. So meaning that the leg is connected to the top. top elements. A patent claim cannot just merely list down the parts. They must connect in some manner. Okay, they must connect in some manner. If you do it, if you just list down everything, like this is one example here, an apparatus for holding item comprising 4 legs, 16 screw and a top, that will be a tendency that your claim will be rejected, because you just basically list down everything, but you never state the relationship between one element with the others. So the examiner has no clue as to the 4 legs, what's the relationship between the 4 legs, the 16 screws and the top. So you need to explain it. You need to explain it like this, like the previous one, a top configured to support at least 1 leg and blah, 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 okay? Now, okay, that's the body of the claims. Let me go into some of the examples that we can do. And of course, I must say, drafting a patent is an art. This is nothing to do with legal. This is nothing to do with science, okay? This is an art, a skill. It's like how you draw, how you paint paintings, okay? How you do a drawing, how you draw your own paintings or whatever. So it's a skill, actually. It's more like a skill than a science. So, however, there are certain rules to it. There are certain rules to it that you must be aware while you are doing your own draftings. Let me introduce you to this new thing, new claims. We call it the 2-part claims, or in US, they call it the Jepson claim, or known as an improvement claim. So how do we draft the, what they call it, in the body? How do we actually focus? How do we actually tell the examiner that these are the improvement of the invention, the scope, the crux of the inventions? Normally, we will use this, we call it the 2 parts. Normally, we will use the word such as characterized by, okay? Characterized by, and in the certain area of the body of the claims, we will provide the novelty or inventiveness of your inventions. So in the European concept adopted by Malaysia as well, we normally will use the word, the phrase, characterized in that or characterized by. When we write when we write anything, we will try to define the scope, the novelty scope of the inventions in the body of your claim. We normally will start a small subheading called characterized in that or characterized by. In the US, it's common that people always use this, wherein the improvement comprises of blah, 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 blah. So either one of these are, acceptable in Malaysia. But, you have to use this to draw down the scope of novelty, for your inventions. Now, let me give you examples of these two-part claims that you can use for when you draft, when you try to list down or the area of novelty for your inventions. Let me give you one example here. A pencil having an eraser, wherein the improvement comprises a light attached to the pencil. So you have a pencil, assume that this is a pencil, and you have this pencil having an eraser. Okay, that means that this pencil includes an eraser. Now the novelty part, the improvement part, is that there's a light attached to the pencil. Where is it? I don't know. They never say anything, but as long as there's a light attached to the pencil. So thus, in this claim, a pencil having an eraser is a relevant known art. So everyone knows that pencils will come with an eraser on top. And then, but because the claim improvement is attached with a light bulb, maybe. How you put it there, we don't know, okay? But it comes together with a light bulb. So this is how we actually define and we explain, we draw down the scope of the novelty scope of the inventions, okay? Now, the third one you must learn is you must know how to draft a means plus function claim, okay? Means plus function claim. The word means it means functional. It symbolizes functional. The word means is symbolized functional. So if I give you some example on your, maybe on my left side, or my right side, sorry, your left side perhaps. These are the example of a means plus function. You see, a means for doing something, performing something. Now, why we use the word means and we're not using any specific structures or any specific elements on it or component on it? Because we are talking about its functionality. We are not talking, its functionality can be achieved by many I would say many different way of elements or structure. So I don't actually have to define a specific structure, but I define its functions. And of course, in my description, in the specification, you need to give examples or give some examples of these structures that can perform such functions. You understand that? So let me give you an example. Means for connecting. Okay, now this is one good example. The format of a classic means plus function claim is the word means. When you draft in your body of your claim, in the body of the claim, sometimes we don't define a specific structures or components for carrying out certain functions of performance. So I would prefer to use the word means to followed by a functions. Let me give an example. Just now we will take back the rice cooker, okay? Let's look at the rice cooker claims. An apparatus for cooking rice comprising, so you have the preamble, transitional, and of course, now the body. A means for holding rice. A means for holding rice. And a heater configured to heat the rice holding means. So you have something, a structural something that hold the rice. And you have a heater configured to heat up that something which hold the rice. Okay, you see, this is how we draft means claim functions. Okay, means plus means function claim. Okay, so that so we have referred device that perform this rice function and all this thing. So next, okay, this is let me just, I hope everyone understand. Yeah, I know it's a bit confusing. This is one of the type of claims that we typically can use to describe functionals, means functional apparatus or functional structures. We don't define any specific structural name or element. Instead, we use the word means, which actually portray its purpose, its functioning purpose. So a means for holding rice and rice holding means. Okay. Now, when you draft means plus function claims, you must keep in mind that it must be accompanied by an adequate descriptions. So you cannot just put in your claims and say means for holding rice, but in your descriptions, you never cite any example or you never define a structures or anything which carry out the function, the rice holding means function. Understand? So when you draft the claims, make sure that the description, in your descriptions, in your specification, you must define the example, okay, of given a structural example of what do you mean, what you actually define by the word rice holding means or means, okay, or specific means. So now, a more special concern for patent drafter when using means plus function claim is to avoid reciting unnecessary structures or not making it clear in the specifications precisely which set structure to perform, thus eventually giving a defendant in. Okay, so remember, when you want to use this in your body of your claims, make sure that you need to describe it in your description. What you mean by the means for doing such and such. Give an example, okay? Something like that. Then of course, examiner will basically understand, oh, what are you trying to do? Or else your whole claim will be strike out due to ambiguity or inconsistency. Okay, number 4, punctuation is very important. It sounds like kindergartens, but lots of people always got this wrong, and your patent can be struck out because there's an error in the punctuations. So you must know when to write a comma. Basically, a comma separate preamble and transitionals, and a colon separate transitional from the body. So these are standard, quite standard. Okay, remember this by heart. So you don't simply do a comma and you must do a colon, an example. Okay, and the semicolons as well. So let me give you an example of the punctuation. Yeah. Okay. Now, example 1. So you have your preamble and apparatus for and transitions comprising of or comprising colon. Element 1, semicolon, element 2, semicolon, but because it's going to end, so you must put the word and. The last one, you must put a full stop. Understand? Be mindful of this, because if you don't do this, you will get a backlash from the examiners. The examiners will hate to see that you have such a improper punctuations. It's very important, very important. Yeah. Okay. Please learn it by heart. Remember this. Antecedents. You must, when you draft your body claims or your whole claims, please remember the correct antecedent basis. Antecedent is very simple. In the independent claim, when you first introduce an element or an article, you must put the word a or and. You cannot start anything with the. No. The first thing when you introduce is maybe and something, and element B and element A, wherein the element B is coupled to element A. When you refer back to the introduced element, previously introduced element, then you can use the word the or said. Now don't use the word the said, just use the. If you don't understand, just simple, just use the. Okay, the is a good word. All right. So antecedent is basically is very important as like your punctuation. It is the law of patent drafting. So sometime I got a bounce back, a backlash from from examiners. Some of my junior drafter actually got the antecedent wrong. So we need to correct it. We need to resubmit the antecedents properly. So remember, all the first time elements, when you introduce, you put a or you put an, and followed by you put the or you put said. It's simple, all right? Very simple, okay? Basic kindergarten English. Okay, let me give you an example here. A device, okay? A device comprising a pencil and a light attached to the pencil. Simple, right? And the number 2 will be the dependent claims. The dependent claims for the first one will be the independent claims. Okay, in every patent, you always started with at least one independent claim. You can have more than one independent claims if you want to. But in this example, I will just give you a small, very simple independent claim, followed by dependent claim number 2 and number 3. Now, if you notice that I wrote in the dependent claims too, the device recited in claim 1 wherein the like is attached to the pencil. Okay, so if you see, I use the, simple. But when I first introduce my elements, I always use okay. So that's it. It's so simple, right? So everyone can be a patent drafters, all right? Everybody can be a patent drafters. I don't mind, you know, because I'm here to communicate, share my knowledge with everybody. I'm not stingy to share. Okay. Always remember, you can also do it this way. When you first introduce first elements and distinguish it from the second element, you can use the word first and second. All right, first and second. So this is how we normally say that this is my first wife, this is my second wife. If you have two wives, or this is my first boyfriend, or this is my second boyfriend, if you have two boyfriends. So alternatively, you can always refer the second one as another, using the word another, because both are male. So you have a first, okay, you always introduce the first as an. I have a boyfriend, or I have a girlfriend. I have another girlfriend. This is just example, just a joke, okay? Because I think everyone will fall asleep if I don't say some humorous, I don't make some humorous statement from here. So you always refer the second one as another. You can use the word another. Okay, I have another boyfriend or girlfriend. I have a boyfriend. I have another boyfriend. I have first wife. I have second wife. All right. This is how you differentiate the two elements belonging to the same. Maybe you mentioned about the same thing, but different what they call it, functionalities. So let me give you an example here. Again, a first widget connect to a second widget, wherein the first widget blah 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 blah. Okay, this is very useful when you are describing something about mechanical or some process. Okay, you are talking about the first at a first hinge connected to a pivoted members, a second hinge, something like that, you know. Okay, or you can use the word another, a fumerangs coupled to another fumerangs. Okay, so this is, we call it antecedents. When you draft a patent, it is very important that you must observe proper antecedents, or else your examiner will be very, very pissed off because he or she doesn't know what are you trying to refer to. So you have to tell him or her that this is the first one and this is the second one, all right? Or this is introduce the first, or you're referring to the same one, you please use the word the. Okay, each independent claim need to be drafted independently with proper antecedents. When you first draft a claim, we always start with drafting an independent claim. Now, independent claim is the mother of all claims. It's very important because you are trying to portray the whole things of your invention through independent claims, especially the novel part of it. Now, you don't need to mention so many things that which are not novel to it, okay? Which are known, or what we have, prior arts, okay? But you are trying to tell the examiner, look, this is my novelty, this is my novel part here. So drafting an independent claim is very essential. And proper antecedent must observe when you draft an independent claim. Let me give you a last one example, yeah? A device comprising means open-ended. A pencil, a light attached to the pencil, wherein the light is attached to the pencil. Okay, so please observe, please take note of the word the, and it means it are referring to that pencil. Okay, now when you draft any claims, please always remember to mark the reference number, the reference parenthesis, what do you call it, reference number. What I do normally is that I will take the drawings. I will first list down all the elements, important elements in the drawings. You see, this is a element A, this is element B, and C and D. I write down in one script. I give them number. I numbered them. Okay, I numbered them. And then when I draft any claims or in the description and claim and abstract, you have to be consistent to use the same numbering for the said elements that you mentioned. So for example, in this figure 1, if in the figure 1, let's say if you have a figure 1 drawings, and patent shows a computer memory, and this computer memory is labeled 1, 2, 3, that means if the claim recite this particular computer memory, the computer memory will be followed by the reference number 1, 2, 3. So let me give you an example here, yeah? Okay, how do we actually do bracket expression or numbering? An apparatus comprising a plurality. I always use the word plurality when it is more than one unit. You can always mention a plurality. Plurality means it must be more than one and infinity to infinity. It can be as many as infinity. So a plurality of printed pages, bracket 11, a binding 14, binding configured to hold the printed pages 11 together. It means you have a binding, a binding. A binding means something, a binding, okay? To hold all these pages together, and a cover attached to the binding. Oh, okay, this is just very simple examples of how we actually, use reference numbers for each important elements. Always remember, all the numbers in parentheses are the reference number for patent from the drawings. Make sure that when you compare with your drawings, the number are tally, okay? Because you don't put here 101, number 101, and here you put 102. You will make the examiner frustrated, and you will make him so frustrated until he will throw back the thing to you and say, please correct everything. So you have to resubmit and correct your own errors and omissions. Okay, so this is very important. Always start with drag and drawings, list down the elements, and use and draft the claims using the reference number as per your drawings and all this thing. Okay, claim phases. Now, when you write any claims, I just introduce some of the important words like the word comprising, consisting, and all this thing. Now, you can also use the words like wherein, whereby, as such, and etc. etc. Okay, wherein, whereby, as such, etc. etc. So let me give you an example. The example you can actually see from my from the from my right side. This is a headgear as per claim number 1, further comprising a visual cover for placement overset, something like that. So the word wherein, you can actually describe more about the functionality, the invention, and all this thing. All right. So make use of this wherein and whereby. The wherein clause is basically used to describe either a function and operations and any results that flow from the previous recited structures. So the wherein clause usually followed by the results. Okay. So for instance, that if you want to claim a folder for keeping files, the claim in a wherein format might read as follow. Okay, you look at the last sentence. A folder for keeping files wherein the folder is configured to receive the files. This is one example lah. So okay, you mention a folder for keeping the files, wherein, I repeat, the folder is configured to receive files. You are trying to describe what the folder is doing. What is the purpose of the folder in the body of your claims? So you can try and use wherein clause to describe that. Am I clear? Should be clear, yeah? Okay, what happens if sometimes I have more than one choices of elements? I can use choice A, B, and C. It works. Should I write 3 independent claims? Yes, you can do that. Okay, in some country will charge you extras, and examiner will be very happy if you pay them extras. And what if I don't want to do that? I want to keep it simple, but allows me to have a choice of either A, B, or C. So we will use these methods. We call it the Marcus claim methods, or alternative elements Marcus claims. Now, a single patent claims consists of alternative elements. We will refer this as a Marcus groupings. So you see, as long as it falls under this unity of inventions, it falls within the same general inventive concept, it falls within the same inventions, okay, concepts. That one, and in that case, you can consider using Marcus claim. Now, Marcus claim is very popular for chemistry, all right, for chemistry patents, because sometimes you can use property A or property B or property C. So, you know, I can give you a range in more than 3, but I'm not going to draft, you know, independent claims for everyone. It's going to be waste my time. So I will use this Marcus claim to actually describe and to link up everything. You can use it for your independent claims or dependent claims. Okay, when you trying to explain the Marcus claim. Okay, let me show you one example. Yeah. Okay. Now, assume that a chemical process could be performed with either a copper, lead, or gold. So a drafter must think of more abstract terms, more generic terms to unite these 3 choices, such as metal. But we know that inventors say that this thing might not work with any metals. Okay, I can suggest the word metal to replace copper, gold, lead, but it doesn't work with any metal. So maybe it only works with this. The best is these 3 choices: gold, lead, and copper. So what should I know? What should I do? I can draft 3 independent claims. One using copper, another using gold, another using the lead, but it will be, you know, my patent specification will be like 100 pages, and the client is not going to be happy, and examiner, when they look at it, they are not going to be happy also. So I can actually suggest to use Marcus claims to group this thing together. So in this one independent claims, I will write like this. I will write the claim in such a way that, you know, it reads like this: a metal selected from a group. I will use the word selected from the group. A metal selected from the group consisting, consisting means very close, yeah, very close, very narrow, yeah, of copper, lead, and gold. So you see, when I write like this, it means that the metal selected from the group only narrowly consisting of either copper, lead, and gold, or gold. Okay, nothing else, just this, either one of these 3. So for this process, so this is how I draft a alternative Marcus claims when you have more than one or many choices of elements that you can choose from. Okay. Now, in the layman term, it's either say, I think I put it this way: a dish, okay, whatever dish, a meals, a dish selected from a group consisting of curry, consisting of you know, herbal soup, and consisting of laksa. So you know what I mean lah, okay? You have a choice of curry, herbal soup, and laksa, all right? Okay, when you write these claims, please do not be too ambiguous, okay? You must be not too ambiguous, and because the purpose of this markers grouping will not directly protect the embodiment of the inventions if it's used other elements not specified in that. Okay, so patent drafter should always strive to cover all patentable embodiment of the inventions. So that's it for the 8 standard claims that you can use to write anything for your body of the claims. So now we move to the next one, the claim sets. Okay, now there are 3 claim sets I will talk about here. How do we actually draft the whole claims with all the claim sets here? I'm going to talk about the independent claims, dependent claims, and multi-dependent claims. Let's start with the introductions first. Okay, a claim set in a patent specification will normally include at least one. You must have at least one independent claims, which is the main claim, the mother of all claims. And you can have a number, a plurality, okay, as many dependent claim or subsidiary claim that you want. But your subsidiary claim must relate to your independent claims. It cannot be standalone, yeah. If it's standalone, means it's another independent claim. So you must have an independent claims. Your independent claims must direct to the essential features of your inventions. It must spell out whatever important elements, essential features, crux of the inventions in the first independent claims, in the body of the first independent claims. As I told you earlier, you can use the word characterized by, what. Okay. Each independent claim. Now you have one independent claim, and you can be followed by one or more dependent claims. So why we need so many dependent claims? Later I will explain to you. Sorry. Okay, so what is the function of independent claim versus the dependent claims? Any claim that refer to another claim, which include all the features of the other claims, even though if they are not explicitly recited, we call this the dependent claims. So the dependent claim basically recites all the features of the previous claim or independent claims, plus something else, Okay. So a dependent claim does not itself define all characterizing features of the subject matters. A claim defined further particular of invention may include all other feature dependent claims shall refer to the same. So if you look at example that on my right side, you see that claim 1 is A plus B. Claim 2 is the dependent claim which refer to the claim 1 plus C. So it means A, B, C. Not sure whether you can look at this. If you observe on my right side, which is maybe your left side. Okay, so that will be the claim 2 will be the dependent claims. Okay, in certain cases, a dependent claim may define a particular feature or features. Now, a dependent claim always refer back to the independent claim. A dependent claim always refer back or to another dependent claim. You can have a dependent claims. Example, the claim number 2 is a dependent claim. So claim number 3, I refer to claim number 2 plus D. So you see, my element, my scope become maybe wider or narrower, always narrower, okay? Always narrower. So your dependent claims can always refer to one or more dependent claims, okay? Always remember that. You must know how to play around with the dependent claims. Now let's look into independent claims. Independent claim is very important in any patent application because it represents the broadest claim, the mother of all claims, the broadest claims. Independent claim, when you write any independent claim, try to use the most generic wordings, elements as generic as possible. I will give you some of the example later, okay? Just stay tuned with us. Don't go anywhere. Independent claim is a claim that stands alone, that does not lead a limitation from another's. Okay, so every claim set begins with an independent claim. Your first duty when you want to file a patent for your own invention, you must learn how to draft your independent claims. You must draft your first independent claim first before you go on and draft another dependent claims. In these independent claims, you must state down all the broadest elements possible. Okay. Now, an application may have, and I said already, you may have more than one independent claims. Depends, but it always relates to the same inventive concept. If you have a different inventive concept, it is not possible to put everything in one patent application. You might consider splitting up to more, maybe a next patent applications. Okay. Independent claims. An independent claim should be typically specified the essential. I always remind you, in the independent claim, please state the most important part of your new inventions. I'm talking about the new improvement or the new inventions, which are essentials. Okay, which are essentials. The claim must be very clear. The write-up must be very clear and directed to the heart of the invention. Right? That is very important. Okay, we understand about independent claims. Now we look at dependent claims. A dependent claim depends on another claim. That's why they call dependent claim. Without the other claims, basically the subsequent claim might fall apart. We don't know. So let me give you an example of a dependent claims. Yeah. Look at number 2 here, example here. The apparatus of claim 1, further comprising. I use the word further comprising to explain that the apparatus as per all in part 1, maybe it further comprising of blah, 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 you know. So whenever you write a dependent claims, basically the dependent claim is saying that it includes everything from the parent's claim plus whatever newly recited in the dependent claim itself. So you don't actually think that the word dependent means not important. Wrong. When you read any claims, you don't just read the independent claims. You also read the dependent claims so that you get a bigger picture of whatever the inventor trying to actually protect, okay? Or maybe they're narrowed down to a more specific scope. Dependent claim should be shorter than independent claim. And most of the even patent agents, many of them actually mistakenly believe that dependent claim should be broader than independent claim, whereas it is wrong. You know, your dependent claim cannot go beyond what is not disclosed in your independent claims. Your independent claim should be as broad as possible. Your dependent claim will spell the limitation, will narrow down to a specific, what they call it, limitation or scope. Understand? So please bear in mind that if you have not recited any new elements, don't do it in the dependent claims. Do it in the independent claims. And then dependent claims, you can actually describe further what do you actually include or what do you mean by that element as you mentioned in the independent claims. Well, I hope everyone should be with me until now. Yeah. Okay, let me just give an example. Assume that an independent claim reads an apparatus comprising a pencil and an eraser attached to the pencil. I took the photo here because this is not me, of course. I just Google it, download from somewhere. And this is just one very good example of a light bulb attached to the pencil. So assume a dependent claim reads the apparatus of claim 1 further comprising a light attached to the pencil. Assume that a dependent 3 reads the apparatus of claim 2 further comprising a pencil lead release button attached to the pencil. So if you look at the whole thing, the entirety of claim 2 includes all the text affirmed recited in claim 2 plus all the text of claim 1. And thus, claim 2 actually reads like this: an apparatus comprising a pencil, an eraser attached to the pencil, and a light attached to the pencil. You'll observe, claim 2 actually mentioned that there's a light attached to the pencil. Okay, and then similar in the claim 3, which depends everything entirely in claim 1 and 2, plus you look at the red color I highlighted, a light attached to the pencil and a pencil lead release button attached to the pencil. So you have another pencil lead release button attached to the pencil. So that is claim 3. So your patent claim, basically you have to read all together. So if you read claim 3, it means that it consists of a pencil, eraser attached to the pencil, a light attached to the pencil, and a pencil lead attached to the pencil. So you have 4 elements there, okay, instead of just 2 elements as per claim 1, the independent claims. So you see the dependent claim basically spell out more narrow elements and more perhaps new elements, okay, to the what they call it, to your inventions here. Okay. Now, multiple dependent claims. Okay, you can depends on more than one claims. Here are the example of a multiple dependent claims. The apparatus of claim 1 or 2, or you can write like this: the apparatus of claim 1 and 2, or you can write like this: the apparatus of one of claim 1 and 2, either one. Okay. The apparatus of one of the claim 1 and 2. So it's something like an alternative. I'm referring to claim 1, I'm also referring to claim 2. It's entirely up to you how you want to write it, but not both, only one. So this is the way we write a multiple dependent claims. Okay. So some jurisdiction they allow, and some jurisdiction they don't allow. Some will treat it like a dependent claims, a normal dependent claims. So example, let's recall the pencil example. And first, an apparatus comprising a pencil and a light attached to the pencil. Second, the apparatus of claim 1 wherein the light is detachably attached to the pencil. Now, this is how a multiple dependent actually recites. You look at number 3, number 3. A pencil recited in claim 1 or 2 further comprising an eraser. Okay, so we are talking about the claim 1 and 2. Okay, 2 separate individual claims, but the third one, we are trying to say that whatever is in claim 1 or in claim 2, further comprising an eraser. Okay, so you have an eraser there, whether it's claim 1 or claim 2. So this is a typical example of a multi-dependent claims. I hope that you can actually watch this video again or my PowerPoint if you still don't understand whatever I'm trying to say. Okay, now I'm giving some drafting examples of various type of claims. Yeah, please bear with me. The first one will be the apparatus claim, a device claim we call it. Apparatus claim or device claim protects embodiment of an invention in the form of a physical apparatus, system, or device. So basically, we are talking about a machine or a thing, okay? An object, all right? A system, maybe a mechanical system, anything. So let me give you an example of a tripod here. A claim that covers a tripod for camera. When drafting a apparatus claim, patent drafter can begin by reciting in the preamble what the apparatus is or what it does. So then, of course, you will list down all the elements of the inventions. Now, essential elements are the one requiring the function for the functioning of the inventions. Okay, basically the essence. You need to write down the essence of the invention, the most important one, the essential parts. Because without this, you cannot function, you cannot perform the apparatus. Okay, the novelty of the invention lies in the essential components. So you have to remember, you have to list down. Let me give you one example here. Let's look at example of the apparatus claim. An apparatus for supporting a camera example here, comprising of a pivotal mounting configured to hold the camera and a plurality of legs arranged to support the pivotal mounting. So you have two elements here, a pivotal mountings to hold the camera and legs, many legs to support the mountings. So when we first write or draft anything, we always, never mind, you can write anything down on your paper, but you have to look back at whatever you have written and think about it. Make a second to think about it. Look at those words that you written and then see how many words that you can remove or maybe amend it to, in order, while preserving the essence of the invention, you can actually broaden up the coverage of the scope of protections. Okay, so let me give you an example here. In the professional tips, on below, I refer back to this tripod here, apparatus for supporting a camera, and the essential camera in this are a pivotal mounting for the camera and legs arranged to support the pivoting mountings. So I may, in this case, consider to remove the word pivotal. Is it strictly necessary? Is it have to be pivotal mounting? Can I just say it's a mounting to support the camera? You think about it, okay? Of course, you are drafters, you must make a choice of your own. Method claims are claims to recite the, as another way. This is widely used for computer programming, processors, chemistry processors. So let me give you an example of how I make a cup of tea example. So in this, basically method claims are a sequence of steps to complete a task. It's a process. Method and process, same thing, right? Okay, so it's a process. So this is example, a method of making tea. The method comprising, okay, of boiling water, adding sugar to the boiling water, adding tea leaves to the boiling water to form a mixtures. So you see, I'm describing the steps and also the event of of the steps. Adding milk to the mixtures and filtering the mixtures. So these are the series of steps performed of the process of making the tea. Okay, sequentials in order they are performed. You see that I use the word comprising. When I use the word comprising, you see, did I tell you just now? Comprising is actually the part of the transitional phase. So comprising is an open-ended phase. So in this example, if you look on my right side, perhaps your left side, I mentioned that as set forth in the claim above, for example, the step of boiling water must occur before the step of adding sugar. So the first step is you must boil the water first. You must boil the water before you do anything. That's the first step. Okay, normally for every steps methods, you do like that. The first step, most essential part, you boil the water. However, the steps of adding the sugar to the water could occur and at any other steps. Example, even like after you add the milk. So you can actually swap. You can actually, it doesn't matter whether you add the milk first or you add the sugar first, but the boiling water will come first. All right. Okay, so in the above claim, you see I mentioned here that the patent drafter will want to consider whether adding milk and sugar is always necessary for making tea in accordance with his client inventions. So when you write anything here, on the first time when every drafter, when they draft anything, they always write down whatever they have in mind. But it is good that you must repeatedly look again and again, review your claims to make it broader. And sometimes you think about it, should I use this word, or should I remove certain words so that I can broaden up my limitations? Okay, so this is the task and duty of every patent drafters. If you want to draft your own patents, you need to do that. Okay. Method claims. In some jurisdiction, they use the word use, and some jurisdiction, they use the word process. So I can write a claim like this: a process of killing insects using substance X. Okay, that's a process. And similarly, a claim for the use of a transistor in amplifying circuit would be equivalent to a process for the process of amplifying using circuit containing the transistor. So, okay, this is the process. You must know how to use the word process, use, okay, all this thing. Now, not all the jurisdiction allow the word use. The best advice for you is you can just either use the word methods or process. I always use the word process for when I draft my process claims, because I think it should be very straightforward, easy. Okay, the process of making a milk tea, or method of making a milk tea, or method of making a milk tea using the steps, blah, 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 blah. Process method is very easy to draft. I think for computer science students, if you discover any algorithms, very fantastic algorithms, or you have discovered any series of algorithms, you can try listing down all this, and then you do it your own, and perhaps you can get your own patents. All right, patent approved. Okay, so another one is the compositions claims. These are the chemistry. This is for chemical people. This is one of the example that how we actually drafted a composition claims, which relates to chemical materials or components. And let me give you one example here. A copper electroplating solution comprising an alkaline solution for copper sulfate from this, okay, this 30 to 50 gram per liter sulfate for this sufficient, okay. Now, sometimes chemical claims can be drafted as narrow as possible instead of the broad claim, because if a thing is too broad, it wouldn't work. So you have to be a bit specific and narrow. So it's okay, it's all right. There's no wrong for drafting a narrow claims. All right. So it's very common that in the composition claim, like this chemistry claims, we always draft things are quite narrow, because in order to perform, to achieve the result, you know, it always depends on the situation. Sometimes people intend to draft it narrowly, or sometimes we intend to broaden up as possible. If we cannot broaden up, then we have to scale down to a narrow and more specific claims. Okay. Product by process claim. Well, if you basically, a lot of people will ask me these questions. If I invented a process and the end result, the product, can I patent the product as well? Yes, by law, and especially in the EPO standards and Malaysia standard, you can actually, the protection of the patent actually extended to the products directly obtained by the process. Subject to, and I say subject to, of course, it must fulfill the three fundamental basic requirements of a patent, patentability, which is novelty, inventiveness, and it must be industry applicable. Now, if you have that, yes, why not? Okay, it will be extended to the product. My advice is that if you have a process of manufacturing a new product or a product, and the product is something new, my advice is that you can actually draw down two independent claims. one for the process, one for the product itself. It's okay because it belongs to the same general inventive concept or inventions. You have a process here and you have a product here, and the product X obtainable by process Y. Yes, we can do that. Okay, now let's come to the last part of drafting your patent claims. And before that, if you would like to download the this video and the what do you call it, my slides, you're welcome. I will give you the link later on. And I have a checklist here, and this is my own checklist, okay, for drafting specification and for drafting, yeah, mostly for drafting specifications, okay? Because today's lecture will be basically touching only on drafting claims, not the specification. Now, when you finish your claim, doesn't mean that you can submit your patent application. You need to also submit your specification, description, everything. So you have to write a big, long story novel, how fantastic your ideas and all these things in the specification. And your specification element must tally, yeah, must go in together, must tally with, you must mention every elements that you have written, you have submitted in your claim site. Okay, tips number 1. This is very important, yeah. Patent drafters, every drafter should start drafting the claim first, as I always emphasize. It helps the patent drafters and inventor better refine the idea of invention in their mind. Once the invention is clear to them, drafting specification is easy. So my advice for you, ladies, gentlemen, listen, draft the claim first. Draft your claim first. If you want to speak to any patent agent, or maybe you want to speak to me, okay, for instance, it's good that you come with your drawings and your draft claims. It's easier for the drafters to actually understand what are you trying to protect and all these things. The specification will follow naturally. Now, tips number 2, broad and narrow claims. There's no law to say that you must draft a broad claim only or a narrow claim. It's like, you know, your steering wheel. Okay, when you're driving a car, a vehicle, you need to know when to accelerate and when to stop, and you must know when to bend, you know, to turn to the left side or right side using your steering wheels. So it's a combination of both broad and narrow claims. But most importantly, you must spell out the crux and the core essential features, essentials of your inventions. Okay, now in any practical matters, I always advise you to start with a narrow claim. It's all right, start with a narrow claim, doesn't matter, and slowly you can look back at your claim sets, your claims, and maybe you can think like, how should I replace certain words or terms with more broader claims? Okay, it takes you many practice to actually become a good drafter. It's all right. Okay, for the first draft claim, okay, let me give an example of this. An apparatus for turning lead into gold. Wow, I have invented a machine to turn the lead into gold, comprising of a metal box like metal frame. I got a metal box frame, an electric motor mounted inside the frame, okay, the metal frame, a bowl for retaining scrap lead housed on the surface of the metal frame, and lastly, a lead gold zapper element attached underneath the bowl and inside the metal frame and configured to receive electric power from the motor, the electric motor. So this is my first view, yeah. When this is perhaps my first drafting. So I am going to relook and revisit my wordings, my claims, to see that I have omitted something, or maybe I should delete off something. to make it a bit broader. Okay. So next, I just would like to touch on this one. Okay, I removed this metal back box claim. I think that's not very essential. So what I have written is that an apparatus for turning lead into gold comprising an electric motor, a bowl for retaining scrap lead, and a lead gold zapper, blah, 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 received from motor. So here, I note that the word electric motor is rather specific. It's rather narrow. Can I broaden up? What are the words that you suggest me to replace it is besides electric motor? So I choose the word power source. Is it broad enough? It can be any power source to power up this whole apparatus. So I will just rewrite it to like this: a power source, a bowl for retaining scrap leads, and a lead gold zapper element appropriately coupled to the bowl and configured to receive power from the power source. Now, okay, you see? So what are the things that I can, I review? And what are the things that I think we can do it, we can maybe replace it, or we really need that few words there? Let's take example, the word bowl, yeah? The bowl element does not really have to be a bowl, okay? In order to, to retain the lead properly. So he noticed, the drafter noticed that he referred the lead as a scrap lead or just lead. So you see, you have to see the words for all your body claims, and then you have to think, maybe there are better words to replace this. So so here I finalized the last copy: a power source, a lead retainer, and a lead gold zapper element operated coupled to the lead retainer. Okay, and I don't call the bowl anymore. I call it a lead retainer. You see, all right, a lead retainer. So I changed the word bowl to a lead retainer, something that holds the lead. So operated coupled. Okay. See, this is the process. When you draft a patent, it's like a journey. Okay? You have the first step, which is on top. And subsequently, you see how I actually remove some of the non-relevant things that I think we can just remove that. We don't need that. We just remain the core, the essential features of the inventions. So I removed the metal box frame, okay? Then I replaced electric motor with power source. I replaced the bowl for retaining scrap leads with a lead retainer. I replaced, and then this is how we actually finalize the final draft. Okay, see, drafting is fun actually. You're playing with the words. So I enjoyed patent drafting or drafting a patent. Sometimes it's a challenge for me, and I do hope that you take up the practice. Try and draft your own inventions, at least try. And maybe if you really need advice, you can always contact us for some advice. Depends whether, of course, just contact us. I cannot help you to redraft everything, but I try my best. Okay, now, when you draft your first independent claims, as I mentioned earlier, you can actually add on dependent claims to the independent claims. Okay, example here, number 2. Let's say a metal box like wherein the power source and the lead zapper are retained inside this one. Okay, apparatus as per claim 1 wherein the power source is a electric motor. Number 4, dependent claim number 4, wherein the lead retainer is a bowl. You see, at the dependent claims here, we are trying to explain some of the elements that belongs to the independent claims. Okay, you can describe that. You can describe that at the dependent claim sections. Okay, you don't have to do it at the front. You can do it at the dependent claims. And number fifth claim will be the dependent claim of number 4. That is a dependent claim also, wherein the lead retainer is configured to receive scrap lead. Yeah, I can do that. I can say like that. So this is how we draft a patent claims, ladies and gentlemen. You need to practice. Okay. Now tips number 3. I just try to be fast. Okay. Patent drafter must be very conscious of the word that he chooses or he chooses. Okay, he chooses to describe the inventions. Now, okay, sometimes you must be like a fortune teller. You must think and anticipate how your infringer actually get around with that. All right, this is something to do with the clarity of the word choice of words and all this thing. Now, the meaning of the terms, the wording that you are using must be very clear for a person having ordinary skill in the art. When it's a screwdriver, you don't say something else, okay? Something that is quite strange and strangers or aliens to any skilled person in this field. So you can use, my advice for you is that use back the industry norms, the industry wordings that you are basically I'm sure you are much more familiar than me in your own respective field. Now, please beware, avoid those words like fast, slow, long, short, tall, wide, perfect, all this. No, don't say that. Okay, don't mention in your claims that my invention is very oil economical or cost saving. No, or the element is tallest or tall, something like that. No. Okay, don't use this kind of words. Now, if you want to explain that you have 2 pieces of wood, and you want to say that the second piece of wood is longer, or maybe the first piece of wood is longer, this is how you should, how you should write it. A first piece of wood, a second piece of wood, wherein the first piece of wood is longer than the second piece of wood, or having a greater diameter, and so forth. This is how you actually write it. Okay. Sometimes you have to compare 1 and 2, right? Now, if a patent agent does use an absolute term in a standalone mode, the patent examiner will likely to ignore it. Okay, patent examiner will normally treat like if you're trying to write a long piece of wood, there's no different with a piece of wood, because the examiner would just ignore that the word long or tiny or whatever. Okay, it's a piece of wood. Okay. Now, do not use the word about and approximately if you do not provide a range. You must provide a range when you write these words. Example, boiling water at approximately 100 to 100 degrees Celsius. Yes, but you cannot say that boiling the water at approximately 100 degrees Celsius. No, because approximately 100 degrees Celsius, you do not give a range, the range of the parameter. You must give a range, all right? Or else your invention claim will be struck off due to ambiguous. Okay, you can use the word preferably. For example, you can use the word like preferably. Example like the element A, preferably something. Yes, you can do that, but you must be very careful, because the whole idea is that we don't want inconsistency, we don't want ambiguity when you draft any patent claims. Now, you are your own lexicographers. When I say that, that means that the choice of words, how you're going to draft your patent, is entirely up to the patent drafters. You can define your terms, you can use the choice of words, but please be careful. There's no room for ambiguity. Your term must be clear to the examiner and to the courts. At the end of the day, the real ultimate challenge will be the courtroom, because the court need to interpret your patent claims in order to defend or to sue somebody for any patent infringement. Okay, let me give you just a quick one. Inconsistency. What's meant by inconsistency is that the descriptions and the claim, if it's inconsistent, then you have some problems. You must make sure that whatever you written in the claims is consistent with your descriptions. Okay, so if it's the descriptions that is limiting a particular features, but the claims are not, then you either broaden the description or limiting the claim. So both, you have to be very careful. Okay, your claims and your descriptions must go consistently together. Okay, when your claim say A, your description cannot say B. Your claim say that this is preferably this one, your description cannot say that it's preferably that one. Okay. Inconsistent. Okay, let me just, number 2, apparent essential features. Yes. Now, if you have written something in your description, an essential features, and you never put it down in writing in the claims, then you have a big problem because it doesn't protect it. So what you need to do is either you amend the claims or you delete off whatever in the descriptions, either one. Okay. Now, examiners, patent examiners, they has a duty to tell you, when the claim is too broad, but they don't have a duty to tell you when the claim is too narrow. Okay, please bear in mind of this. Okay, and if there is the inconsistency between the claims and the descriptions or the drawings, so you either broaden the claims or you remove the excess subject matters. Yeah. Okay, and I think I'm not gonna also. Okay, let's just come to the last part. This is our phone numbers, trademark to use. And if you like to download this IP Talk slides, you can download from here. The IP Talk episode 8 will be uploaded to our YouTube and our website, perhaps someday after today. Okay, so that's it. And wait, let me just stop share here first. Okay, well, I believe I have come to the last part, and I thank everybody for spending, what's the time now? Oh, it's 3:45. So it's good. It's less than 2 hours. We managed to go through some of the important parts of the what do you call it, of patent draftings. Okay, perhaps I can allow some Q&A today, since we still have some time. But we will have 10 minutes of Q&A. But let me